Good morning. Well, good afternoon, technically. Welcome to Alexander Lloyd's November 2021 Employment Law Update webinar. I must come up with a snappy title for that. I'm just going to let you all arrive slowly. I can see the numbers piling in as we speak, so I'm just going to waffle for a while you all land with us. Right, while I've got you there. So, welcome to our Employment Law Update webinar. For those of you that don't know us, Alexander Lloyd, we are your HR recruitment specialists in the South East, primarily Surrey, Sussex, Kent and London. And we've been enjoying your company for about 22 years now, which is longer than I've known my children. So it's lovely to see some of you again. This is our third and final HR webinar this year in partnership with Andrew Knorpel. Morning, Andrew.
Good morning.
Andrew's with us again.
Good afternoon.
Afternoon. I know. Still feels very morning-y, doesn't it? Sorry. Good afternoon. Andrew Knorpel from Synchrony Law is with us once again. I should take a brief moment to explain if I look a little unwell and sound a little unwell. I am on day 6 of COVID self-isolation. I'm only allowed in this room and one room upstairs, which I think my wife is actually quite enjoying, frankly. I think she's got used to not having me around now. But apologies in advance if I sound a little ropey. Anyway, pressing on. Do stay at least 2 meters from your screens throughout the presentation. Today, we plan to cover a general update on employment law. So there'll be examples of cases and important legislative developments, including recent government proposals for new legislation to carers leave, flexible working and sexual harassment. Andy's also going to provide an update on data protection developments that affect employee data, including a number of initiatives and decisions from the Information Commissioner's Office. As with all of our presentations, we'll invite questions via the Q&A button, and I will pose these at the end. And if there's any natural break, we're anticipating an hour really for the entire event. In terms of Alexander Lloyd, I think you know myself, Simon Geere, my team, Martin Heitzman and Theo Saunders are also available to help you with any HR recruitment requirements you may have. And most importantly, I think today, for the first time, we will have nailed the feedback form at the end of the presentation. So when you finish today, you will immediately be presented with a short tick box exercise to let us know how you found today. Please do complete this, as it really helps us know that you're still interested in talking to us and what you'd like to talk about next time. But I think that's everything from me. If you are sitting comfortably, I shall pass you over to Andrew, and hope you enjoy yourselves. Many thanks.
Good afternoon, everyone. I'm Andy Knorpel. Many of you will know me over the years, having presented a variety of seminars and now webinars in conjunction with Alexander Lloyd. Very much looking forward to presenting this one with you today. And as Simon has mentioned, we're going to be looking at a variety of topics, including one recent case, some government proposals, and some things that the Information Commissioner has put out as well. So I'm going to hopefully now share my screen with you. And hopefully now you can see my slides today. So we're going to start with menopause in the workplace. Although the menopause has been around for rather a long time, it has really only featured in, I would say, employment policy over the last couple of years in a major way. In fact, it has now reached the House of Commons, where the very influential Women and Equalities Committee opened an inquiry, which recently closed, on menopause in the workplace. And this particular inquiry was looking at a variety of aspects of menopause. And it had three main aims. The first was to review existing legislation that protects those with menopausal symptoms. Now, at the moment, those who are suffering from the menopause can be covered by a variety of laws, including age, disability, gender reassignment, sex discrimination. Those tend to be the main discrimination claims or protections that people have. And if they are constructively dismissed or actually dismissed, then unfair dismissal and obviously health and safety laws as well. I'll look at a couple of claims that people have brought in the past in due course. The question is, though, is the ability to bring these existing claims sufficient to prevent people leaving the workforce because they just can't cope with their menopausal symptoms anymore, or suffering other disadvantages in the workplace? Do people need more legal protection in order to be able to have a good working environment, notwithstanding the menopause? A survey a couple of years ago, CIPD Bupa survey, found that 3 in 5 menopausal persons were adversely affected, and almost 900,000 left their jobs over a period because of symptoms. Now, it's not clear over what period that survey was carried out to get that 900,000 people. However, clearly, whatever period, it is a substantial number. And clearly, this is something that we would try, if we possibly can, to remove, limit going forwards. But it's not just legislation that the inquiry is looking at. It's all well and good having legislation to allow people to enforce their rights. However, really, we want to look at recommendations for future policy. What policies can we put in place, both government policy and other policy, in order to try and ensure that employers implement good practice going forwards? And menopause affects the wider society as well. So it's not just necessarily individual employers and what policies should be available for them, but what can government do generally to make sure that those who suffer from the menopause take a full and active part in society? And having looked at those two parts of the inquiry, they will then consider whether further legislation is required. It might be that they suggest that a specific menopause policy should be put in place. We've seen other legislation that requires specific policies or statements to be put in place. Gender pay gap reports. We've got the modern slavery reports that people are required to put in place and even publish. So the question is, should employers be bound by law to have a menopause policy in place? Also, if the inquiry finds that the existing laws are not sufficient to enable people to bring claims, should they make menopause a specific protected characteristic under the Equality Act, in the same way that pregnancy and maternity are a specific characteristic separate from sex discrimination? At the same time as the inquiry was taking place, there was a survey, some research took place in the financial services sector. And very recently, they published the results of that research. And it could probably be thought that similar results would appear across the whole of the UK workforce. It found that around half of people in the financial services sector going through the menopause were reluctant to apply for promotion or take on extra responsibilities. They just felt that their symptoms prohibited them from doing that. They'd find it too difficult to do so. A quarter said they would like to leave their job altogether before retirement, simply because of their experience, their symptoms, and the way that they were being treated. And unfortunately, a number of things factored into these figures. They found that across the entire workforce, there were taboos, a culture of silence in the workforce, in the workplace. The issue of menopause and the physical symptoms simply weren't discussed. People didn't want to bring it up through either embarrassment or lack of understanding on the part of management and employers, as a result of which many experience negative reactions in the workplace. So we will wait to see what the government inquiry produces. They will come up with a report probably next year. And from that, we will see if the government decides to take forward any further consultation on the issue. As I mentioned before, there haven't been many cases on menopause, but there has actually been one very, very recently. It actually came out only last month. And this was the case of Rooney versus Leicester City Council in the Employment Appeal Tribunal. Now, in this particular case, the claimant had severe menopausal symptoms. She was already prescribed HRT and was under the care of a consultant at a special menopausal clinic. So, not that there are run-of-the-mill symptoms, she had severe menopausal symptoms. However, like many people suffering from the menopause, she was embarrassed and uncomfortable discussing the symptoms and difficulties, particularly with male colleagues and managers. And to be honest, her employer didn't particularly help. When they arranged an occupational health report because of the adverse effects on her work and her absence because of her menopause, she wanted to be seen by a female doctor. No, the employer simply couldn't arrange for that to be the case. And when she got a final written warning for stress absence because of her menopausal symptoms, in the appeal hearing, there were 4 men present, which again, it made it very difficult for her to discuss and raise issues that concerned her. Also, another example of the difficulties that she faced was the fact that when she did address her concerns to her male manager regarding her hot flushes, he simply replied, "Well, I get hot too." Not a particularly understanding response. Obviously, it led on to her having to resign from her employment, and she ended up claiming constructive dismissal, sex discrimination, and disability discrimination. Various claims, but I'm only going to concentrate on disability discrimination here, just one aspect of that case as well. Now, she went to the Employment Tribunal, and the tribunal struck out a variety of her claims. But the reason they struck out her disability discrimination claims was they simply said, "You're not disabled." Now, you may be aware that in order to prove that you are disabled, you must show that you have a mental or physical impairment that has a substantial and long-term adverse effect on your day-to-day activities. And the wonderful case law that we've had has defined substantial as more than minor or trivial. It's not a particularly high bar to cross. However, the tribunal decided that her day-to-day activities, the effect on them as a result of her menopause, was not more than minor or trivial. But they didn't explain why. They also said that she wasn't relying in her case on the physical symptoms of menopause. She was only relying upon the mental and psychological symptoms. Well, that completely contradicted the evidence. And they also found that her symptoms didn't last at least 12 months, but she had given evidence of the fact that they lasted over 2 years. And so on the basis of this, the Employment Appeal Tribunal, amongst other things, upheld her appeal. But let's look at the evidence that she'd actually given. And you may wonder, how did the tribunal actually reject her claim that she was disabled? She gave evidence that wasn't challenged, that she had hot flushes, sweating, palpitations, anxiety, night sweats, sleep disturbance, fatigue, poor concentration, urinary problems, headaches. That's just one set of symptoms. All of this led to her forgetting to attend events, meetings, appointments, losing personal possessions, forgetting to use the handbrake on her car, forgetting to lock her car, etc., etc. As you can see on the slide there. You may wonder how on earth the tribunal had found against her, but you can see why the Employment Appeal Tribunal, actually with this unchallenged evidence, decided no, she was disabled and allowed her case to go back to the tribunal on that basis. Various other claims were also appeals that were upheld and were remitted on other bases as well. But that's gone back to the tribunal, so we may hear more about that case in the future. Other things that have happened in relation to the menopause is several years ago now, ACAS gave us some guidance. They gave us some guidance that you can find on their website. And in this guidance, they remind employers that menopause can affect women, trans, and intersex people. And that is why earlier on in my slides, I referred to menopausal persons as opposed to female employees. In fact, something else that they refer to here is it deals with supporting staff through the menopause and training managers in developing a policy. I must admit that it was only a couple of months ago that I ever had my first training session on menopause in the workplace. It really now is a topic where training and having policies really do help people's understanding. And having those policies and having that training could avoid cases that we have had in the past. There was one case, Merchant and BT, where a manager dismissed an individual for poor performance without obtaining any occupational health report whatsoever after she had told him that her menopause affected her concentration. Mind you, the manager did not follow the proper policies of the organisation, but he clearly treated this employee as a woman less favourably than they would treat a man, and as a result of which that was a successful direct discrimination. There was another case, Davies versus the Scottish Courts and Tribunal Service, where a clerk in the Scottish courts, unfortunately, who was taking medication, had put medication in her water on her desk and then thought in court that other people might have actually drunk her water and therefore taken her medication. And she got in a bit of a state because unfortunately she was mistaken about that. No one had drank her water, but she created quite a stir, and this all occurred because her perimenopausal condition caused her to become forgetful and confused. And when she was dismissed for the state that she had got into in the public court, it was found that that was discrimination arising from disability, because her state of mind was caused by her perimenopausal situation. I'm now going to move on to another proposal that the government actually has put forward for carers leave. The government has had many proposals recently, and in a consultation back in March last year, they were consulting on unpaid carers leave. As you may be aware, at the present time, an individual has the right to take unpaid reasonable time off to look for dependents. And this could be to arrange care suddenly when something suddenly happens. However, it's not a natural right to provide care. And what the government was proposing would be that there would be a right from the start of employment, known as a day one right, to to take up to 1 week's leave per year to care for individuals. And the government announced that they would take forward this proposal. They announced it in September this year. We don't know when they're going to implement it. They've said when parliamentary time allows, and there was nothing in the employment, there was no employment bill in this session of Parliament. So hopefully we'll find it coming in next year, or perhaps coming into force in April 2023. But they have said they're going to bring it in at the same time as changes to the right to request flexible working, which I will come on to shortly. Now, this particular right to take 1 week's carer's leave is going to be based on the relationship between the individual and the person being cared for. And they're going to use the same definition of dependent as the right for unpaid time off. Now, in order for this individual to be able to fall within the definition, they must have a long-term care leave, unless they are terminally ill. And this could be defined as one of three things. They've either got a long-term illness or injury, either physical or mental. The government could choose the definition of disability under the Equality Act, which I've previously mentioned, which, as you're aware, needs to last for at least 12 months. 12 months will be likely to last for at least 12 months. Alternatively, a third definition could include issues relating to old age. And this particular right will allow individuals not just reasonable time off to arrange things, but to actually provide the care as well as making arrangements for care as well. And it will be available every single year. You'll need to give notice, and that notice will be twice the length of the leave that you're asking to take, plus 1 day. A bit similar to the ability to the notice for statutory holiday. There'll be no need to prove that an individual needs care. No, it will be all self-certified. Simply, if you say that I'm going to be providing the care, that will be sufficient to be able to exercise the right. Clearly, if you are misusing this right and you aren't in fact going to be caring for anyone or arranging care, then that will fall within any possible disciplinary action that can be taken against the individual. As with other types of leave, the leave can be postponed where business operations would be unduly disrupted, but it cannot be denied. In other words, if the individual wants to care for somebody, they will have the right to take that time off at some point. I mentioned that the government's considering bringing that right into force at the same time as the amended right to request flexible working. Well, that right to request flexible working is something else that the government has recently announced in September. Although in this case, what they've done is, following a consultation 2 years ago, they are now consulting further on the precise terms of those changes. And the consultation is still active here. It closes in a month's time on the 1st of December. So if you wish to put in any submissions, please go onto the government's website and you'll be able to do that. Once again, this will be a day one right. At the moment, the right to request flexible working is only available to those with 26 weeks service, with half a year's service. So right from the start, people will have the right to say, I wish to work flexibly. And as we know, the right to work flexibly can mean many, many things. It could relate to the place of work, the hours of work, the timing of work, the way in which work is done, a number of different ways in which flexible working can be requested. And as we know, because of the COVID pandemic, employers are probably going to find it much harder to reject requests to work from home, I think, than they did beforehand. At the moment, there are 8 statutory business reasons for being able to refuse a request. And in light of the pandemic, the government is consulting on whether those 8 statutory reasons are still valid. It could be that they narrow the reasons, abolish the reasons, merge the reasons. Again, we'll need to wait and see what their response to the consultation is on this. But at the moment, employers have 8 statutory reasons that they can reject a request. When you are considering a request, we always advise employers not to just reject it out of hand, but if you possibly can, suggest alternatives. Simply done as a matter of good practice. The government is considering requiring employers to suggest alternatives, I presume, where they are available. We would always suggest that you do. And one alternative that I always recommend is, if at all possible, if you really don't think that you can agree on a permanent basis to an individual working from home or working certain hours, trial it. The law doesn't actually allow a trial as a response to a request, but if you can get the employee to agree to a trial, that will also help us, assist defending a claim for a failure to agree to their request. Or indeed, if you do refuse a request point blank, that could lead to an individual arguing that they are constructively dismissed, or even arguing that they have been discriminated against on the grounds of sex, if they are looking to care for a child. Being discriminated against on the grounds of age, potentially, if they're looking after an older relative. Hopefully we can avoid that by, if you can, putting in place a trial period and reserving the right to revert back to the original terms if that trial period is not successful. Now, the administrative procedure at the moment for making a request for flexible working is that you can only make one request a year, and the employer must deal with it within 3 months. Again, the government is consulting on whether that administrative process should change. For instance, should you allow more than one request a year where an individual's personal circumstances have changed? For instance, they have another child, or their parent requires additional care. There could be any number of reasons, but perhaps a life-changing event. 3 months to deal with the request is probably quite a long period for an employer to deal with. Although, if an employee makes a request while they're off on maternity leave, an employer will almost always want to use that full 3 months to deal with the request, so they can see what the situation is more likely to be, perhaps, when an individual is returning to work from maternity leave, and what are the circumstances more likely going to be like when they do. But let's see what the government comes up with in this regard. Another thing that the government is looking to do is raise awareness about the right to request a temporary arrangement for individuals. So if something crops up in an individual's life where they want to change their hours of work, but just on a temporary basis, again, that is something that can be requested, but individuals may not be aware of that right. The government wants to raise awareness about it, and that will be, and for instance, that could be that they require an individual to have a flexible working policy in which they make this very clear that if you do have a need on a temporary basis, you can ask for that as well. The government at the moment does have a flexible working task force up and running. At the moment, they are been very focused on how the new ways of working have changed in the light of the COVID pandemic. And because of the government's requirement that wherever possible at various times over the last year and a half, people should have worked from home, they're presently focused on the location aspect of flexible working requests. However, towards the end of this year, next year, the government is asking this task force to focus more on issues of line management and organisational culture, on how requests for flexible working should be addressed. One of the things that was originally consulted on but is no longer being put forward is whether large employers should be required to publish flexible working policies. That is not being taken forward. One thing to emphasise is these changes, if and when they are brought into force, still do not give individuals the right to work flexibly. It is simply the right to request flexible working. And even though this right, if it does come in, will apply from day one rather than from 26 weeks, I'm sure that you, as many employers, when you are recruiting individuals, those individuals are often saying to you right from the start, may I work on a flexible arrangement? May I only come into the office certain days? May I work these hours? Or may I work condensed hours, etc.? And they will be asking for that in the recruitment phase. So we'll need to wait and see whether the change from 26 weeks to a day one right really does have that much effect going forward. In the meantime, another report has come out, a evolution of the workforce. Evolution of the Workplace report was published last month, and this surveyed over 7,000 individuals across Europe and the UAE, including 2,000 from the UK. And it was quite clear from this report that a sizable minority was hoping to return to the office only 2 or 3 days a week. Conversely, a substantial minority were also concerned that working from home, if they were required to do it, would have a negative impact on their career development and progression. And this actually turns into a majority when you look at people aged 6 to 24 years. And I think that's right. In the early stages of our careers, we learn so much by osmosis, not in the chemical way, but absorbing what we see and hear in the workplace from our peers, from our managers, from our senior colleagues. Definitely, as a solicitor, I learned so much. I remember, from sitting in those first few years, when I was both a trainee and a qualified solicitor, from sitting in with more senior solicitors and seeing how they worked and seeing how they advised. And you learn so much in that regard. And I do think that it has been much, much harder for individuals in the early stages of their career to develop whilst they're at home. As you can see, a majority of people think that they will miss out on learning opportunities from peers and senior colleagues. So I definitely think that will continue to be a reason, it's shown from surveys, for perhaps rejecting requests from individuals in the early stages of their careers to work from home. Moving on to domestic abuse. It's definitely the case that the COVID pandemic and people being required to work from home has exacerbated the risks of domestic abuse for those who are less able to escape from their abuser, where their abuser is in their home. The government did recognise this and published an open letter to employers in January this year, calling on them to ensure that they were spotting signs of domestic abuse, which obviously wasn't particularly easy when they were dealing with people who were still working from home. On the same day as that, the government department, the BEIS, also published a report on improving workplace support for individuals experiencing domestic abuse. And ACAS followed this up with their own guidance from working from home, dealing with the health, safety and well-being of staff. Domestic abuse is not something, I think, that employers have had at the top of their mind when thinking, how should they be looking after the health and safety of their staff. However, where individuals are working from home and there is an increased risk, and just generally because individuals who are suffering from domestic abuse may show signs in the workplace when they are back working in an office or other environment, it is possible for employers to sense what might be happening in the background. And therefore, the guidance calls on them to look out for potential signs of domestic abuse and guides them on how to deal and respond appropriately. How to provide the support that these individuals might need to keep a record of the incidents and the actions that are taken. Now, all of this is well and good, but this isn't going to happen unless people who are looking out for these signs actually understand what they're looking out for. And again, ACAS and other organisations recommend having, or at least considering having, a domestic abuse policy, so individuals understand what can be done and the availability and signposting as well, where help can be obtained. On the actual ACAS website, you'll find that they refer to the CIPD and the Equality and Human Rights Commission guide, and also a Business in the Community toolkit. And other organisations are signposted where help and support are available. It is not the case that employers are supposed to understand and know everything about domestic abuse and the signs of domestic abuse. However, if you do have a policy and training, it will provide assistance to your staff in the workplace. It will reinforce your commitment to taking reports of abuse seriously, and hopefully it will create a culture where awareness of domestic abuse and open conversations about it are encouraged. Now, it is definitely the case that those suffering from domestic abuse may be extremely wary about saying anything. However, if you have a culture in your workplace that fosters the opportunity for individuals to be able to say something, then you hopefully can provide support or signpost support that is available. Because you do have a requirement to look after the health and safety of your individuals, of your workforce, including those who are working from home. And therefore, there is actually a legal duty on you, to some extent, to deal with this. And risk assessments, talking to your staff about the environment at home can bring this out. You know, I've set out here your legal duties to provide a safe system of work, to ensure, as far as reasonably practicable, the health, safety and welfare of all your employees, and to take reasonable care of the health and safety of your employees and provide a reasonably suitable working environment. This applies in their homes as much as it does in the office or other workplace. You do have legal duties here. I haven't ever seen it argued so far that a failure to look out for domestic abuse at home could amount to a breach, but it is most definitely arguable. And organisations who are obviously encouraging you to keep an eye out for the domestic abuse of your staff are obviously making sure that you are aware of your legal duties in this regard. Moving on to sexual harassment. Another government consultation took place in July 2019 on tackling sexual harassment in the workplace. This came out of very much the Me Too, the hashtag, and everything that was happening at that time, and the concerns that still continue to be presented. Now, at the moment, there is no current proactive duty on any employer to take steps of having a policy and putting training in place. Now, if an individual brings a claim of sexual harassment or sex discrimination against an employer can try and cut the alleged harasser loose and say, we took all reasonable steps to ensure the discrimination harassment did not take place, and therefore we are not liable for the acts of our employee who discriminated, who harassed. If you may recall, in the last webinar that I gave, I talked about a case where harassment had taken place, but there hadn't been any training for several years. And so the tribunal found that the failure to provide updated training meant that they hadn't taken all reasonable steps. But at the moment, the only need to try, the only legal reason that an employer might want to take all reasonable steps is to have a defence to a claim. And I would suggest that many people would say, well, hang on a sec, that's simply not good enough to use it as a defence. And so the government has decided that in light of that, they want to introduce a new duty to prevent harassment. In the same way that there's currently a duty to prevent money laundering and to prevent modern slavery and to prevent the facilitation of tax evasion. These are new positive duties being imposed upon employers. We don't know when it's going to be put into place. We're told it's as soon as parliamentary time allows. So again, I think we could be looking at perhaps April 2023. There will be a defence, which is where all reasonable steps have been taken. The Equality and Human Rights Commission will be able to come after employers who they believe have failed to comply with the duty and require them to take steps to put in place steps to comply with that duty. And they're going to issue a code of practice in that regard that will be backed up with government guidance. Now, the consultation was in relation to tackling sexual harassment. It's not clear whether this new duty and the code of practice will apply to all forms of harassment in relation to all relevant protected characteristics. I would have thought that they would. Harassment is harassment, whatever form it takes. But we need to wait and see there. What we also need to do is we need to wait and see what employers are going to do generally here, because I would suggest that you do not wait until April 2023 to put in place policies to deal with this. You may say, we've already got a policy in place. We have an anti-bullying policy in place. The issue is, though, many new forms of bullying and harassment have taken place over the last, let's say, 2 years to deal with what I'm going to call recent issues. There has been far more harassment taking place over social media recently. Perhaps over Zoom, Teams calls that take place, because it's not so much taking place in person. By WhatsApp messages. These issues also need to be covered in any policies that you have. Hopefully, you might have them covered already, but if you don't, please do think of updating your policies to have them covered rather than waiting till perhaps this duty actually comes into force. Another aspect of the consultation is third-party harassment. When the Equality Act first came in 2010, there was a provision which said that an employer was liable for the acts of third parties where they happened at least 3 times. But that was thought to be too unfair and was basically repealed 3 years later. The government has decided that we do need something back. We do need it back again. And this particular duty is going to be put in place when parliamentary time allows. We're going to have a similar all reasonable steps defence, but otherwise employers will be liable for third-party harassment. Now, you may say, well, how do we prevent third parties, those who we deal with, those who come into our offices, from harassing our staff? I think it's going to depend, it's going to be different for every single employer. But you may see signs, signs up in various workplaces, railway stations, other public-facing organisations, which already say, the signs saying, we take harassment of our staff very, very seriously. And anyone who does so will be barred from our premises, etc. That is probably going to be the minimum that is going to be necessary. It may be necessary for organisations to put provisions in place in their terms and conditions when they deal with third parties. Now, that doesn't initially appear to be an employment issue, does it? That seems to be perhaps a responsibility of your procurement team or some other department within your organisation. But I think you're going to be having to liaise with them and have something like that in place going forward. Something that the government was thinking of doing was extending the scope of sexual harassment liability to interns and volunteers. They've decided that interns are already covered because interns should already qualify as workers under the legislation, so they're covered. And they've decided that it would just be too much hassle to have volunteers covered legally by the Equality Act. And therefore, the duty to prevent harassment and harassment generally liability will not be extended to volunteers. However, it will be that you'll be expected to have an anti-harassment policy in place to cover all staff, including volunteers. Other things that we're looking to have is to extend the time limit for all discrimination cases, all discrimination claims, from 3 months to 6 months. At the moment, there's a 6-month time limit for bringing a claim for equal pay claims, but nothing else under the Equality Act. The government is looking closely at extending this time limit for all discrimination claims, not just harassment claims, but all claims, for a number of reasons. Firstly, grievance procedures can go along, when somebody does have a concern, you don't want them bringing claims, you want them raising it internally first. You want them to bring a grievance, but to be tried to raise it internally first. But grievance procedures, including appeal procedures, can take a long time. They can also take a long time if the individual is not at work as a result of the discrimination or the harassment. Or indeed, they may not be at work because they are on maternity or other statutory leave. So for this reason, the government is looking closely at extending this time limit here to 6 months. However, they recognise that there are many tribunal claims going through the system at the moment. There were before the pandemic. It's got even worse since the pandemic. And they basically don't want to put a huge burden on the tribunal system by having a larger number of claims being made, and therefore they're going to allow the tribunal to try and reduce their current caseload before they bring this provision into force. The government also consulted back in January 2019 of extending redundancy protection for those on maternity leave to 6 months after they returned to work. At the moment, for instance, if somebody is on maternity leave, they have what I call super priority to be considered for any particular vacancy over and above any other individual that is potentially redundant, even if they're not the best person for the role. And the government is considering extending that to those people at least 6 months after they returned from maternity leave. And they said back in December 2019 that they were going to do it. The government got chased on this in July, and they responded saying, we will do so as soon as parliamentary time allows. I think there's going to be a lot of things that are probably going to come into force in 2023. The government was also pressed on ethnicity pay gap reporting. We all know, as you're all aware, we've got gender pay gap reporting at the moment, and the government consulted back in October 2018 on ethnicity pay reporting. The CIPD, back in September of this year, called on the government to introduce it for larger employers from April 2023. And on the 21st of September, the government said they will respond to the consultation in due course. No time limit here whatsoever. But they did explain why. They said, we've still got a number of concerns here about how we're actually going to implement such a duty. We're concerned about having a large enough sample size for conclusions to have any validity. But we also don't want, in organisations where there is only a small number of people of ethnic minority, but you to be able to identify them and their salaries. They're concerned about low response rates, making sure that anything does not breach data protection. They're concerned where certain ethnic minorities might have such low numbers that the figures would be meaningless. So perhaps they might combine different ethnicities in order to mitigate low response rates and to make the data more meaningful. So at the moment, yes, that is going to be brought into force, but we don't know how and we don't know when. And finally today, I'm just going to deal with a few data protection developments. Hopefully you are all aware that the Information Commissioner published an Employment Practices Code 10 years ago, and also some quite substantial supplementary guidance. And this all dates back to 2005, although the latest issue was 2011. Now, this guidance and code was based on the pre-GDPR legislation, the 1998 Data Protection Act. And obviously, with the GDPR and the new Data Protection Act 2018, and just the development of the ways in which we deal with data generally, that particular code is very much out of date in some respects. So back in August of this year, the government opened a consultation exercise that closed on the 21st of October on updating its guidance to basically bring that guidance and the code of practice up to date with new ways of working and the ways in which we use new technology. Now we had a new Information Commissioner, starting in their role only a few days ago now, and so the outcome of that consultation exercise will be dealt with by that new Commissioner. Until that takes place, the current code is definitely something that you should be looking at whenever you are dealing with data, and I regularly refer employers to that. Separately, the government has got a new code of practice in force in relation to data sharing, and that came into force just under a month ago now. And in relation to employers sharing data, it emphasizes that employers should avoid relying on consent as the lawful basis of processing. Now, I would remind you that there are a variety of reasons, of legal bases for processing data and sharing data, and whenever possible, you should avoid relying on consent. The reason being, consent can be withdrawn. So you always want to be relying upon one of the other legal bases, such as it's necessary for to implement the contract of employment, or it fulfills one of our legitimate interests, or it's necessary for reasons of employment. All of these are legitimate bases, and they should all be set out in any privacy notice that you have for staff. And then finally today, I'm just looking at data subject access requests. The bane of many employers' lives, you get hit with one of these by your employee. And when I'm advising employees or former employees, it's most definitely something that we use in the armory. They are a fantastic way for an employer to gain access to information about them and find out things that they'd rather not find out. What people said in emails about them. The first, second, third, perhaps even fourth, fifth, sixth drafts of that termination letter to see how did it change from the first draft to the last draft. One particular recruitment agency received a data subject access request from a claimant who was bringing employment tribunal claim against them. They made a data subject access request, and the recruitment agency failed to comply with that request. And when the individual complained, as they have every right to do, to the Information Commissioner that the organisation had failed to comply, they said they'd been instructed by the employment tribunal they didn't need to respond to the request because documents will be exchanged in due course in accordance with the tribunal's directions. However, the claimant then forwarded a letter from the tribunal to the Information Commissioner, a letter that they had sent, which specifically said that the tribunal has nothing to do with data protection requests, as they call them. And the important thing to remember here is don't lie to any regulatory body, as this recruitment agency did, about what the employment tribunal had actually said. But more importantly, perhaps, or equally as importantly, is if you receive a data subject access request, it is completely separate to any tribunal proceedings that are ongoing or might yet be brought. In this case, the organisation failed for over 8 months to respond to the request. They failed to demonstrate compliance with their data protection obligations, and as a result, the Information Commissioner issued an enforcement notice against them, giving them 1 month to respond to the subject access request, and reminding them that if they fail to do so, they could be liable for a penalty of up to £17.5 million, or 4% of their annual worldwide turnover, whichever is the higher. There are significant penalties here for failing to comply with data protection. My advice, always respond to data subject access requests and deal with them in a timely manner, irrespective of any employment tribunal proceedings that there may be. And that is the end of my presentation today. Simon.
Thanks, Andrew. Excellent stuff. We've just about got time for any questions, if anyone's got time to tap them away. But in the meantime, obviously, I wanted to say thank you to Andrew for some great updates on some quite sensitive areas there, actually. And most importantly, the recruitment agency involved in that final story was not Alexander Lloyd. I just want to clarify that. Felt it needed saying. But I mean, so far, no questions, Andrew. It's clearly a sign you've explained yourself very, very well. If anyone does have any, then obviously feel free to drop either Andrew or myself a line over LinkedIn. It's probably just as easy a way of doing it. But what we will do after the event is we'll set up a page on our website, as we always do, which will have Andrew's slides, and we'll also put a link to the video to this webinar so that you can watch again, so to speak. If that's all right with you, Andrew. I don't know if there's anything else to add from yourself before we say have a lovely afternoon to all these HR people that we're talking to today.
Thank you very much for allowing me onto your screen again.
Marvellous. Oh, there's a quick question here, Andrew. Oh, no, it's not. It's just a get well soon for me. Thank you. I will try. Day six. Stay strong. Thank you, everyone, and we'll see you again soon.
Thank you.
Many thanks.
Bye.
Cheers. Bye-bye.